All right, so what's the difference between a will and a trust? All right, as a financial planner, I really encourage my clients to have certain estate planning documents in place, such as a will, a power of attorney, and sometimes a trust. And one of the common questions I get is, hey, what is the difference between a will and a trust? And you may have that question as well. So let's get into it. But before we do, if this is your first time here, my name is Keith Wilson. I'm a practicing financial advisor, and I've dedicated this channel to help people like you to learn more about personal finance. All right, so let's talk about wills and trust. And first of all, know that I'm not an attorney, and this does not constitute legal advice. I'm just here giving you general educational information to help you. So let's start with a will. A will is a document that is created that expresses your wishes when you pass away. And inside that will, you will state who gets what of what you own. And you will also name someone as an executor that is responsible to make sure your assets are distributed to the beneficiaries that you name in the will. But before your executor can distribute all your assets, your estate will go through what is called probate. And the probate process that involves the court system. So the executor would go to the estate division of the courthouse and produce the will. And understand this probate process involves a lot of steps to follow, a lot of time and court costs. So the executor would have to compile a list of everything you own, and this is called your estate. So think of it like this. Your estate is everything that is in your name, such as your house, bank accounts, investments, or brokerage accounts, properties, such as land or rental properties, vehicles, stocks and bonds, and household items such as furniture. And perhaps in your will, you may have wanted certain individuals to have a portion of your assets, right? But before they can get it, the probate court would have to oversee this whole process, which again, that takes time. And by the way, your will is public record, so anybody can go down to the courthouse to see who gets what. And if you die without a will, then the court will appoint someone as executor and decides who gets what. So now let's talk about a trust. There are different types of trusts, but one of the common types of trusts is a revocable living trust. Now, this is a document that is created, and like the will, you are dictating your wishes. And inside the trust document, you would name a trustee, it's usually you while you are alive, and a successor trustee that takes over after you pass away. And what you do is transfer everything that is in your name to the name of the trust. So instead of you owning the house, bank accounts, investments, properties, vehicles, stocks, and bonds, the trust would own it. So it's as simple as retitling the asset from your name to the trust's name. But don't worry, a lot of people think, oh, I've got no control now, right? Because the trust owns it. No, that's not the case. But don't worry about that, because as the trustee, you can still do whatever you like with your assets. That wouldn't change. What would change would be the probate process. So you see, if everything is owned by the trust and not you, then there would be no estate to settle. And the assets owned by the trust could be distributed according to what the trust arrangement is. It could be distributed immediately upon your death by the successor trustee, avoiding the probate process. And that's one of the attractive things about having a trust, to avoid that probate process. The other thing is the trust can be managed well after you pass away. So perhaps you have some children that are not so good with money, and you want to make sure they don't get all of their inheritance at once, right? Well, with a trust, this is something you can dictate well in advance of how they receive the monies, or properties. Now, one mistake I have seen by clients that come to me that have already established a trust is that it was not funded. What does that mean? That means assets and properties were not transferred to the trust's name. So just because you have a trust, it must be funded. You know, the good thing about a trust is it avoids probate, but there are assets that would avoid the probate process without having a trust, such as life insurance with named beneficiaries, retirement accounts with named beneficiaries, and joint accounts. Now, it's important to note this, that not everyone needs a trust, but everyone should have a will. So I know there's a lot to unpack here. There's a lot of things to consider, and this is not a situation where, you know, hey, which one is better, a will or a trust? And that's why you should consider talking with a qualified estate planning attorney to help you with this, all right? So, hey, thanks for stopping by. I hope you found value in this, and if so, please subscribe to my channel, give this video a good thumbs up, and we'll see you next time.